Good afternoon once again. A warm welcome to everyone joining us in person and online. My name is Eka Rostomashvili and I'm a campaigner at Transparency International, where I focus on cross-border corruption issues. It is my privilege to be moderating this panel today with a very outstanding lineup of speakers. For months, much of the world's attention has focused on holding Russian kleptocrats accountable and on finding ways to sanction their illicit wealth. But because the vast majority of kleptocratic wealth is hidden through layers of secrecy, even the most willing governments have been struggling. Beneficial ownership transparency has been key to uncovering illicit assets, and our community has been right to focus on this issue for over the past decade. While we have had many successes, there's still a long way to go until we can confidently say that criminals and the corrupt can no longer abuse corporate secrecy and hide behind anonymous companies to mask their ownership of assets and wealth. Today, the beneficial ownership transparency agenda has a number of moving pieces, from trusts to investment funds, from real estate to luxury goods, to data verification to public access. And as we address each of these issues, there's also one other solution that we can, and at least some of us in this room believe that we should, pursue simultaneously, and that is creation of a global asset register to record the real owners of properties, luxury goods, and other high-value assets. Beyond increasing traceability of unexplained wealth and helping to achieve accountability, a global asset register would help shore up the funds that are currently being lost to corruption and tax abuses, and funds that are desperately needed to finance sustainable development and help to reduce inequality. And it was precisely from the tax justice and inequality lens that economists Gabriel Zucman and Thomas Piketty proposed creation of such a register several years ago. The European Union is particularly well placed to move forward and to undertake steps towards a unified register of assets, not least because of progress on corporate transparency. As 22 out of 27 countries had established public registers of companies' beneficial owners. That is, of course, up until 22nd of November, which is when the EU's highest court ruled that the anti-money laundering provision that ensured public access to company beneficial ownership registers is invalid. So if originally we had planned to dedicate this session to a conversation on strategies and practical aspects of setting up a global asset register from a position of relative strength when it comes to corporate transparency, together with our speakers, we have decided to reframe our conversation a little bit and also to weigh in and comment on the ruling. And considering its implications, discuss ways on advancing the agenda, the transparency of asset ownership agenda forward in the EU and beyond. And we could not have wished for a better lineup of speakers to have this conversation with. I'll briefly introduce each of them. You will have time to also ask them questions at the very end, also as well as for the online audience. Let's go in alphabetical order. Anette Alstasetter is a professor at the School of Economics and Business of the Norwegian University of Life Sciences and head of Skatteforsk Center for Tax Research. She studies tax evasion, tax avoidance, and inequality, and has published in top academic journals. Annette has been highly involved in the public debate and policy work. She writes a column in the Norwegian media outlet DN, and is a member of the Swedish Fiscal Policy Council. Eilif Flidal is an investigative journalist at VG, a Norwegian outlet, most read news outlet. Eilif and VG's financial news outlet E24 led an international investigative project known as Dubai Uncovered, which revealed how criminals, corrupt public officials, and sanctioned politicians from around the world have poured money into Dubai real estate. He has worked on investigative projects uncovering corruption, illegal working conditions, and also hidden investments of illicit cash. Andres Knobel is the lead researcher on beneficial ownership transparency at Tax Justice Network. He's a lawyer focusing on tax law and public policy. He has deep expertise on everything from financial secrecy to tax havens, beneficial ownership registration, and automatic exchange of bank account information. He has worked as a consultant for the Inter-American Development Bank, the UNODC, the UN High-Level FACTI Panel, GIZ, EU-AML Global Facility, and the Green Party to the European Parliament, in the European Parliament, among others. Mayra Martini, my colleague, is a research and policy expert on corrupt money flows at Transparency International. She leads our movement's global work to disrupt the systems and mechanisms that enable grant corruption, cross-border corruption, and kleptocracy. She's often the first person who journalists covering financial crime will call to help make sense of complex financial crime schemes. And over years, her work has led to significant impact. Just most recently, earlier this year, the revision of the global standard on beneficial ownership transparency of companies is something that I'm so proud to say that my colleague Mayra was the first one to recommend in her 2019 report, which looked at the FATF mutual evaluation reports. So each of our speakers will share some very interesting and complementary insights, and we will make sure to save some time for your questions. So please note your questions, and also if you're joining us online, to send them in the chat. And now back to why we're here. When we talk about assets, we are particularly interested in wealth, in the amount of trillions that the state budgets are currently missing in stolen funds or uncollected taxes. Our first speaker has studied the extent of the problem and has worked to answer the question, do we even know how much hidden wealth, how much finance and hidden wealth is there offshore? Annette, the floor is yours.
Okay. Thank you. Who evade taxes? Well, traditionally, we have said, based on what we know from tax authorities' audits, it's basically saying that the poor evade and the rich avoid, because it's the normal guy who's been caught in audits done by the tax admin. And here you can see we have had a big, together with Gabriel Zuckman and Ernst Johannessen, we had this big project together with tax admins in Scandinavia and journalists. We actually used randomized audits done by the Danish authorities, and merged all families, basically, and we have wealth, and also basically take all families in Scandinavia, all of Scandinavia, and rank them by their wealth. So the lowest, the poorest at the right, and up to the high, like the wealthiest families at the left, and the wealthiest at the right. So what we see from what the Danish tax admins could find who evaded taxes, well, it's basically all around. It's not, you don't see anything, like around 3% of taxes paid that should be paid were evaded on personal taxes, because in Scandinavia everything is automatically reported, so you can't underreport your income basically. So that's conventional vision. There's like the normal guys evade. But this is basically just because we can't observe what's hidden abroad. And that's the dilemma today. We have globalized economy, but we have national authorities. So basically the information stops at the border. So we can basically, if you want to hide your actions or your assets, you can just take a detour through a border, and you can also take it home. And if you even take a detour through a tax haven and have a shell company or trust, it's basically impossible to see who are the real owners. So through a big collaboration, we used Swiss leaks, Panama Papers, amnesties. We were able to see who actually hid money abroad. And we were actually to see who had hidden assets in Swiss leaks, and like totally overrepresentation by the rich. We saw the richest people in Scandinavia, the richest family, hid 40% of their wealth. 1% of the richest Scandinavian families had an unreported account in HSBC Switzerland. That's one bank in one tax haven at one point in time. And like 1% had an unreported account. We actually, because it's not illegal to have money and assets in tax havens, you should report it, and we could actually check with the tax admin they hadn't. Taking this into account, we can then distribute, like what we know is like basically wealth corresponding to 10% of GDP is held by households in tax haven financial wealth. That's become stable over time, even like through the information exchange agreements. Taking that into account, we just suddenly find that it's the rich people who evade their taxes. So the richest families in Scandinavia, taking into account what was hidden abroad, evaded 25% of the personal taxes they should have. This is like totally new, and it actually changed the way tax admins were able to think about this, because you need also to have structures to try to catch also the affluent. These are data from 2006. We don't have newer data. So basically what we know about like hidden assets, that's from researchers, NGOs, and journalists. It's super difficult to find new data. And also that's a problem with the CRS, this automatic exchange agreement, because now the countries are sending information back and forth. That's super good, but we are not allowed to use it to have new knowledge and insight on the extent of hidden assets. Taking this into account then, this changes totally what we know about inequality, because inequality is measured often by admin data, basically using what tax admins know. And that's how we like have this wealth concentration in different countries. So what we know from the wealth concentration, this is the top 0.01 richest people in the countries, how much of total wealth they own. The blue is basically what we know from conventional data, and then we add what we know from our hidden asset, the hidden estimates, and see that in many countries there's major holdings of assets from the richest are abroad. And this is particularly known if you see in Russia, the rightmost one, 60% of the richest Russians' assets are held abroad in tax havens. And that illustrates then how difficult it is. Like now, after the invasion of Ukraine, we want to have sanctions to the oligarchs, but we can't sanction them if you don't know the assets they own. But luckily now we have more information exchange, CRS, FATCA on financial assets. Is all problems solved? No, we don't. This does not include real assets. So what do you see? There's indication of hidden assets. If you want to hide assets, you take it into real estate. And this is a project that we have had borrowing data from C4Ads. Grateful for that, thank you. And we have collaborated also with journalists that Eile will talk you more about. And we were able to estimate the total value of real estate on all of the real estate in Dubai and attribute it to country by country ownership level. And here we can see the map indicating that the darker blue is the more like prone to own in Dubai. We see that neighboring countries are more, and historical ties are very prominent. Interesting enough, if we look at, this is for all the properties owned in Dubai, and it's not public knowledge who owns. If you zoom in on the neighborhoods with more affluent, like the richer neighborhoods, the Russian share increases, which is also an indication. Yeah. But you don't need to go that far. Like most countries don't have property registers, central property registers. We don't know who owned properties. Like it could be that it's basically owned by oligarchs or like a criminal asset. So one of the big steps moving forward is to have centralized, proper, reliable real estate registers on a country-by-country basis so that we can start exchanging data as well. Thank you.
Thank you so much, Annette. This is a perfect segue to our next presentation by Eilif, who has led investigations into Dubai Uncovered, as we said earlier. And he will tell us what he and his partner journalists found when they got their hands on the precious real estate data from Dubai. Take it away, Eilif.
Hi, thanks for inviting me. Thanks for Transparency International to set up this panel. To the guys in the back, is it possible to switch to the HDMI cable? Thanks a lot. So my name is Eilif Fleidel. I'm a journalist with Norwegian media outlet VG. I have been working alongside with reporters and colleagues in our sub-financial outlet E24 for quite some time, working on an investigation into Dubai property that we have called Dubai Uncovered. You good back there with switching the monitors? If not, we can just run it from the main file that you already have.
Yeah, run from there and you can follow in your
Yeah,
computer.
let's do that. We can Okay. Right. Okay, so that's me. So we've been working on a project called Dubai Uncovered, which has been investigating properties in Dubai. And the way we've done that is by getting access to a data leak provided us by C4ADS, which is an American, Washington-based NGO that have harvested such information. And in this collaboration, there have been about 25 newsrooms. We've been looking at more than 800,000 Dubai properties, an estimated net worth of $32 billion, owned by 274,000 owners. So the interesting thing about looking into this is as it's suddenly like Dubai actually do have a beneficial owner registry of properties, right? So with, you know, the activists arguing that they want a beneficial ownership registry, well, this is kind of Dubai's beneficial ownership registry of property. That's what we've been allowed to peek into. And so the leak, for the first time, has provided a detailed public overview of those who bought property in this Middle Eastern financial center. And in the initial phase, we've been focusing on European owners and European backgrounds, including Russian owners. I'm not touching anything. It's not me, promise. Hey, I'm back. Thank you. And so I've been working with E24 coordinating this collaboration, and then we had different media outlets coming on board. These are some of them. We were 25 in all. OCCRP joined, which you're probably familiar with, and then a lot of European outlets all around the Baltics, the Balkans, and Western Central Europe. So what did we find that kind of demonstrates Dubai's role and Dubai's role in facilitating international crime? Well, it's no longer a hypothesis or a theory that Dubai is a harbor of illicit money and people with a dubious background. We documented throughout the investigative work in 25 newspapers that criminals from around the world wanted fraudsters, European public officials accused of mishandling public funds, and sanctioned Russian politicians have poured money into Dubai real estate over many years. And in many cases, these pricey properties are difficult to square with the low-known incomes of the owners. So why is Dubai such a place that you want to invest illicit money? Well, it's a modern city. How many of you have been to Dubai? Can you raise your hands? That's quite a lot of people. Did you have a good time? Did you invest in property? No? It's a modern city, and it has zero tax. And it has extensive secrecy and easy to set up a shell company. It's easy to arrive on long stays on a golden visa. It's few and weak extradition treaties. It's a short distance to Europe, Middle East, Singapore, Pakistan. You can buy property with cash, soon with crypto, probably. And it's cheap to launder money this way. You get a rate of, a return of 5 to 10% a year if you rent out the property. Do any of you know how much it will cost you to walk out into the street of Washington and try and money launder $1 million, the percentage you're going to pay? Could be 5%, could be 40%. You risk losing all your money. You don't want to do that. It's much better to just pack your money in a bag and go to Dubai and buy property. And you'll even have a nice annual So, you don't want to be this guy. You could be this guy, which is an advertisement from a Swedish newspaper. It says, Dubai, a different world. And I read that in a Swedish hotel this summer when I was vacating, and it just like in my face. So these are a list of the biggest investors per country. It's an interesting list. You say on the bottom, there are a lot of countries in between. So these are the two main areas of interest we've been looking at. The palm marina. One of the guys we found was Ruslan Bayzarov. He is among the noteworthy, he's a wealthy Russian businessman behind several large infrastructure projects and close to the Kremlin. He's also close to Chechen dictator Ramzan Kadyrov, and that earned him the nickname Kadyrov's wallet after financing several of his, allegedly financing several of his larger projects like the Voduchi Winter Park outside of Grozny. He's also fond of, he likes gilded guns and sending mercenaries to Ukraine to fight in the current ongoing invasion. And when we found when we find properties listed with him as an owner, we also combined that with satellite footages to document when they were built, when the pool was filled with water, and when he moved in. Another one was Alexander Brodai, the first DNPR prime minister. OCCRP published a lot of names like this. You see there are pink for controversy, blue for charges, green for conviction, pink, purple for investigations. Quite a lot of people they found, identified of Eastern and Central European background. We found these two gentlemen. The fun thing about looking at a beneficial ownership registry is that you start with the answer and going to find out what the question is. So when you find these two gentlemen from Norway with 11 properties between them worth approximately $2 million, you wonder, where's the money from? Because I never heard of them, and nobody I talked to ever heard of them. Well, suddenly I found out they were charged with a $2 million tax fraud in Norway. Well, that gave a lot of answer to the question. And these are some of the buildings we discovered when we went down there to document it. So the only thing the police managed to seize was this Lambo that is now in a police garage. And that was all the money they could seize. The rest was off to Dubai. And while, one of them was driving his golf cart around playing golf and publishing cool quotes on his blog telling how great a businessman he was out of reach for Norwegian police. And we started tracking them through British Virgin Islands and other places. And we published in May 2022, and they returned to Norway September 2022, and is now currently in jail and on a trial for that tax fraud. Another thing we found was that during the bail hearing, they admitted to owning the properties that we had found. And they also described how Dubai Interpol treated them in 2018 when briefly brought in for questioning upon a request by Norwegian police. And that was basically explaining that the judge didn't care what they were wanted for in Norway. He only wished them to enjoy the sun and enjoy Dubai and let them back out. And they stayed in Dubai for 3 years. And we made that a public bail meeting. They're usually not public, but we complained to the judge and were allowed to refer publicly from the jail meeting. I'll be very quick because I know I'm running out of time. But the case of Norway is probably the one we spent the most time on because Norway is a very transparent society where you can pull a lot of information on individuals. And what we found was that in Norway you have to report property abroad for the purpose of wealth tax. And out of 260 owners, 214 are actual taxpayers to Norway. And we found out that 85% did not list their Dubai property on their tax records. 85% of the owners. And of course, neither did they list their income revenue from renting them out, because why would they do that? Also, a lot of them were in contact with law enforcement, jailed, in prison over drug smuggling, fraud, tax fraud, etc., etc. And 20% of the total Norwegian properties were owned by people who are either sentenced to long imprisonment or on the run from Norwegian police. That is quite a high percentage in a country famous for having low crime rates. So you can imagine what it would be in other countries as well. It's part of an international pattern. The Kinahans, etc., also large owners. So I'll rest it from there. But that is why we need, as a journalist, beneficial ownership registry, because we can do fun journalism like this. Thank you.
Thank you so much, Eilif. Quick question. I think the cases that you presented, they were all of properties that were owned in the names of the individuals, in the owners, right? Did you also come across cases where real estate was owned by companies?
Yeah, there are. This one live? Yeah, well, there are cases of people owning through businesses, or businesses owning and you're not sure who the owner is. I honestly have to say that we've spent so much time mapping the individuals, we haven't really had time to really start on the companies yet. But there are definitely a lot of company owners as well that should be explored.
Thank you so much. Yes, that's exactly what our next speaker, Mayra Martini, will talk about. The majority of the corruption cases that we look at indeed show that real estate is more often than not owned through anonymous companies. I will not say anything else, except for just to add that Mayra will highlight how EU-registered companies have been a critical piece of the puzzle, and what the Court of Justice ruling also means to the fight against cross-border corruption. Thank you.
Thank you. Thanks, everyone. I hope you can hear me well. From here is a bit of a weird echo, so yeah, bear with me. So good afternoon to everyone. I want to start also talking a little bit about this property and this man there. I will continue in the Dubai theme, but just to make clear that Dubai is not the only place where people are going to launder their money. So here in the picture is Igor Shuvalov. Apologies for my really bad Russian pronunciation. He is a former first deputy minister of Russia. And in 2018, there was another leak of real estate properties from Dubai. This came from a database of real estate of a private real estate agency in Dubai. So you had a lot of interesting information there from the clients beyond the legal owners sometimes that are registered. And this database showed that this $8 million property was owned by a company in the UK. This company, in turn, was owned by a company in the British Virgin Islands that was owned by another company in British Virgin Islands. Journalists were able to consult the UK beneficial ownership register, and they were able to find that the real owner of this company was the children of this man. And therefore, they were also the beneficiary, so the owner of this property in Dubai. But despite of several denounces of his involvement in corruption schemes, I don't think anything happened since this investigation was uncovered by journalists back in 2018. And then we can fast forward to 2022. The war in Ukraine starts, and he is sanctioned, first by the EU, then he's sanctioned by the US, he's sanctioned by the UK, and so on and so forth. His children are also sanctioned. So you might think now it's very easy, right? There was this 2018 investigation, there is a property in Dubai, let's go and find that property. But things are not that simple, because what happened is that in 2019, right after journalists published this investigation, what they did was to dissolve the company in the UK, and yeah, we don't have more information of who owns the property, because there is no real estate information available from Dubai. So we are back to zero, because the company no longer exists. We don't know who is behind that property. And this is just one of many examples, right? You can go to the Russian asset tracker that OCCRP and other journalists work on just after the war, and you're going to see a lot of cases like this one. It's not simple to connect an asset to an individual. It's not simple to connect an asset to an individual, even if you have information on the beneficial owners of companies, because information on asset ownership is not easily available. I want to very quickly talk about one more example. And this is to show that how beneficial ownership information is crucial also so the population can know the dealings that politicians in their country might be doing, the favors that they might have to return, and so on and so forth. So here is a yacht. I think it's a 20 million yacht. And journalists in Hungary had a brilliant investigation during 2018, 2019. They did really brilliant work of following this yacht and following a private jet, and took pictures and used drones and used small boats and so on. And they were always taking photos of who was in this yacht. And they would see people really close to power, so people in positions of power in Hungary. They would see actually the president using the jets and so on. And they didn't know who was behind the company owning the yacht. The only thing they knew was a company registered in Malta, and that's it. In the register in Malta, what you could find in 2018 was probably a corporate service provider. Putting this corporate service provider on offshore leaks, for example, you find another 200 companies connected to them, so not very useful. So they published all these investigations in 2018 and 2019, and the only thing they could say, yeah, we have government officials in really high-level positions, enjoying trips and so on in 20 million yacht, and we don't know why and how and to whom they are connected, right? And then in 2022, when the register of beneficial ownership in Malta became available to the public, they were able to see who is the owner of this yacht. And they found a businessman that was actually flying quite low in Hungary, but very quickly it became one of the most rich men in the country, and because he had a lot of contacts with the public administration. So he was winning public procurement across the country and doing, as you can see, a lot of favors here to different people. So I think it really shows the power of having access to these registers. And I think it's really sad to come here to say that it might be very difficult for us from now on to see investigations like this happening. Because 2 weeks ago, the European Court of Justice decided to invalidate the provision of the EU Anti-Money Laundering Directive that enabled the public to access the register. And while the court said the journalists and civil society have a legitimate interest, they will not have public access. So they will have to prove to authorities that they can access this information. I can tell a little bit more the challenge that we faced when this was the case before public access was a reality. And what I think I want to show to you, so the situation in Europe before the ruling 2 weeks ago was like this. Looks pretty simple, the map, so everything in green was public access, and then you have a couple of private registers, and you have countries that failed to comply with the directive, although we have already close to 3 years after the deadline. Of course, public access was not that it worked perfectly, right? There were a lot of challenges, registration, fees, and so on and so forth. I'm not going to go into detail, but that's how it looked like. Immediately after the ruling, we see already 8 countries suspended access to the registers. Malta is one of them. Didn't take really long to close the register. The first one is, of course, Luxembourg, where the case came from. And then you have also Germany, Netherlands, Austria, Belgium, and Cyprus. Didn't really have public access, but yeah, already shutting down access to the register. And I mentioned access to the public is closed, and I said we have a significant impact on the ability of journalists and civil society of using these registers. But there is more than that, because all these years, foreign competent authorities, so foreign law enforcement, foreign financial intelligence units, have also been using public access to be able to do investigations. We are talking here about individuals in one country that use companies from another country to buy assets in yet a third country. So they need to be able to access registers outside of their countries. And now they will have to go back to rely on very complex international cooperation that we all know might take years for them just to find out who is behind a company. And there is also more to that, because in some countries, or in most of countries that have registers, access to other types of authorities that are not those directly tasked with the fight against money laundering also depends on public access, public procurement authorities, audit bodies, election courts, local organizations, they all rely on public access as well to be able to use this information. So this is definitely going to affect all these actors as well. And I think beyond that, I think we can reflect a little bit more on what the court said and what is coming next. But I think my time is up. And 2 minutes? No, I can do this in the next round. That's good. Perfect. Yeah. Thank you.
Thank you so much. Thank you, Mayra. Yes, we'll definitely come back to you for on the way forward. And in the meantime, Andres also has some words to share on the Court of Justice ruling. He spent a lot of, it's been a lot of early mornings, I believe, for you the last couple of weeks as you've joined your European kind of partners. Debating and discussing the strategy. But beyond that, Andres will also make the case for why we need more transparency, not less, and not just of companies, but also of various types of assets, and also share with us some of his findings from the scoping of the UK, the information and data on various types of assets in the UK.
Yeah. Thanks all. So I work for the Tax Justice Network. I mean, I don't know if you know it, but we tend to be considered a bit radical compared to even to other NGOs. But in a way, all the things that I might be saying today, they're not really things that we expect them to be happening tomorrow. I mean, we try to think more of the long term, like where the world should be like, maybe 10 years from now, I mean, hopefully before. And many of the things that the Tax Justice Network was saying even before I joined, about automatic exchange of information, registration and public access to trust beneficial ownership information, the country-by-country reporting, for those of you who are also from the tax world, we were taken by crazy back like 10 or 15 years ago, and many of those issues are now mainstream. So I hope that some of the ideas that I will share today, even though they might seem a bit extreme, I guess we should say not everything has been discussed at DJN, so I will just be speaking more on a personal basis, although I think at some point many of these policies will become, hopefully, the organization's perspective as well. So the ruling that Mayra was talking about, and I'm sure if you came here, it's because you are aware of that. It did not only get the timing wrong, just especially if we think of the war in Ukraine still going on and enforcement of sanctions actually being very, very complicated, but I feel they also got the data wrong. So when you look at, I'm sure many of you have already read the ruling, but paragraph 41, in a way, is quite relevant because the court says that the series of this interference on the privacy and the human rights of these anonymous individuals, in a way, the main problem of that is that this access to beneficial ownership information about their companies is information that is capable of enabling a profile to be drawn concerning the state of their wealth, their economic sectors, and the countries and everything where they invest. So basically what they're saying is bioinformation as available in Luxembourg registries was enough to know the wealth of these people, and then based on this theoretical risk that whenever they travel, they might be subject to kidnappings. I mean, that was the argument that we've heard over and over in many places. And our answer is, if only it were that simple. I mean, we wish beneficial ownership registries of companies were enough to determine the wealth of people. I mean, that's eventually what we want to know and what we think should become, or at least what I think, should become publicly accessible. And that would have made enforcement of sanctions easy, fighting corruption, fighting money laundering, tax evasion, even measuring inequality, that is ultimately what we think all of this should be about. But in a way, beneficial ownership transparency, I mean, the identity of the beneficial owners of companies, that is just the tip of the iceberg, even in the ideal scenario. If we think about biotransparency based on the anti-money laundering directive, that is the tip of the iceberg. I mean, the directive has many loopholes. It talks about 25% threshold, it doesn't cover foreign companies, there's low compliance rates, there's no update in many cases, no verification. So that which is mostly inaccurate clearly wasn't enough and isn't enough to determine the wealth of people. But even if we gave, for the sake of the argument, that beneficial ownership that is available in these public registries, or that was available in these public registries, was correct, was updated, was verified, it really says nothing about the wealth of the person, for two reasons. This might refer to a company that it's just a shell company, meaning a company without assets, without offices, without employees, really nothing, just a shell company used to launder money, just a part of any scheme. Or it might just as well refer to a trust or a company that actually holds millions in assets. In either case, there's no way to tell them apart. I mean, information from BO registry says nothing about the assets of the company. In the best case scenario, if a company or the trust is subject to accounting requirements and they file according to international standards and information is publicly available, you might get some information on general information on assets, most likely based on book value, not on market value, not updated, no information about where the assets are located or what they are. And now I'm going to talk about a scoping study I did a few years ago for ICRIT, the Independent Commission for the Reform of Corporate Income Taxation. And it's a scoping study in the UK covering, I think, 20 types of assets, from crypto assets, art, livestock, yachts, aircraft. And even in the case of a country like the UK, which is way more advanced than many other countries who don't even have addresses or even a land registry, even then information is really limited, both for authorities, let alone for the public. So you're not expected to be able to read the table. It's just look at the colors. This follows traffic light colors. So green is good, yellow is kind of okay, red is bad. So these are I think, like 20 types of assets that I covered. So we have interest in legal persons like companies, private jets, and this is based on the best cases. So BO of company's house would be the best case. I mean, like a typical BO register. We have racehorses, IP, land and property, extractive industries, interest in trusts, yachts, rural land, cars, trade securities, livestock. In countries like Argentina, where I'm based, livestock is actually one source of wealth, like camels can be in other Middle Eastern countries. Bank accounts, gold and precious metals, art and antiques, jewelry, cash, and crypto assets. So the best case is, again, companies. And already we know that the UK registry has many challenges, especially on verification. But so at least it is central, that's the first column. At least there is public access and online and for free. There is, in cases, legal ownership, in cases, also beneficial ownership, I mean, in most cases. But for instance, we have no information about the price or the value of the company. And for a company, again, maybe the financial statements might say something. But if we go down the line, and you can see the last column is about the price or the value, in most cases we have a no. So even asset registries that could be a source of wealth information say nothing about the price or the value of the asset. But if we keep going down, for most cases like private jets or racehorses, it's only legal ownership. I mean, that shouldn't be green. I think that should be more of a yellow, but I guess we were trying to be a bit more optimistic. But then also, if you keep going down, I don't know how to get that back.
Yeah. Not yet.
Now how to get the table back.
Could we keep the slides, please? In about 3 minutes, we would like to switch.
Okay, so basically, for many types of registries, there is even for many types of assets, like the ones in the bottom, art and jewelry and cash and crypto assets, there's not even a central register. There's not even a register. So there's no information even being collected by authorities or by anyone. Some cases were interesting, like racehorses. That's actually quite a pretty good public registry. And now when you try to get information when you try to register ownership over a racehorse, the interesting thing is that in most cases, they would ask for your prefix. Is it like a Mr., Mrs., Doctor, PhD? In here, the options were Baron, Prince, King, Sultan, His Majesty, and that gives you an idea of who are the owners of racehorses in the UK. But now, even though we don't have enough information from the assets, there are still alternative sources of information. And again, members of parliament do have to disclose a lot of data, and that is publicly available, and covers land and property, shareholdings, gifts, and a bit of other. HMRC, the tax administration, does collect a lot of data through capital gains returns and inheritance tax returns. But another interesting case is wills, or are wills. Wills, I'm sure you know, the concept of that is much less riskier than a trust, and still wills are subject to much more transparency than trusts, unless you are from the monarchy. So when Prince Philip died, his will actually was not publicly available. So for most British citizens, if they have a will, that is publicly available information that you can find online of all the assets that someone is leaving to their heirs, as long as they still have the assets. Not in the case of the monarchy. And actually, the argument was that they need to preserve the dignity of the Queen and her family and her family's privacy. So as we will see with a lot of the issue of the GAR and this global asset registry is that there's usually a set of law that applies to everyone else, most likely most of us, and then other set of rules that apply to the rich and the wealthy, and most likely the criminals, who can stay above the law. So, 2 minutes, okay. So I think it's very clear that we need information on assets, on beneficial ownership of assets. That's important for money laundering, for corruption, tax evasion, asset recovery, but also to estimate and to tackle inequality. I mean, even the existence of billionaires is as Oxfam keeps showing how that is. So we do need this global asset registry. We can discuss the details that should be public or not, the types of assets that should be subject to registration, but I think it's very clear that we need a GAR. Because this GAR, this concept of having information on the beneficial owners of assets like real estate or a yacht or a private jet, is really about changing power dynamics. Powerful people like elites, criminals, they already have access to data if they want. They can either buy it from private companies that sell this, so it's confidential as long as you don't have the money, otherwise it does become public. Even if they don't have registries, they can just go and any person can just check in an expensive neighborhood who lives there, who drives expensive cars, who sends their children to elite schools. Like, you don't need a BO register, even an asset register, to know who has wealth and who doesn't in a country. Again, the criminals can still hack, can do espionage. So it's actually the lay people's information who is already publicly available, and not for anti-money laundering. I mean, most cases, you will go and register your house or your car for private property protection. You want the state to protect you. And when you want to buy a house, when you want to buy a car, you want to make sure who the owner is, just to prevent fraud, not money laundering, not tax evasion. And for most people who don't really go to a tax haven or who use offshore entities, their information is publicly available and has been for many, many decades, or even longer than that. It is only those criminals or high net worth individuals that go to the lawyers and the accountants and then use tax havens or offshore entities. Those are the ones enjoying the secrecy. Everyone else, their information is, again, most likely publicly available already. So this concept of the GAR, having information on the owners of assets, is really about shifting the power dynamics. It's making a level playing field and disclosing information on those most powerful and sophisticated. And in a way, society already gives away a lot. I mean, most of you who are lawyers know that companies are usually called legal fictions. They don't really exist in nature. They don't grow on trees. It's just something that the law decides to give them, and that has a consequence. That has a price for everyone, and that means that they get tax incentives, they get limited liability. In the case of a trust, they might even get full immunity, and that means that if the trust or the company goes bankrupt, it is taxpayer money that has to respond. So at the very least, we should be getting information on who owns these assets. I mean, they're getting all these protections from the state, all these costs from society. At the very least, they should be disclosing who they are. Otherwise, it's like having the cake or cutting it and eating it too. So that will also enable us to know how bad inequality is and how to address that, and also to know who the wealthiest are. I mean, as our colleagues were saying earlier, it's not just good to be reactive, like we have a company, we're under investigation, we want to know who the beneficial owners are. As he was saying, sometimes the BO is the answer, and then we want to know what happened, who the money is from. And there's all of this preventive access that we can have once we have information on the asset ownership. We can start challenging them. How did you get the money to afford all these mansions and yachts in the first place? Otherwise, it's a case of unjustified enrichment. So just to finish, I think I'm way over my time. Again, beneficial ownership of companies, that's just the tip of the iceberg. The ruling affected us, and we'll have to find ways now altogether to counter that, but that's just the beginning. I mean, we are really coming for much more than just BO of some companies. We really want beneficial ownership of assets. Thanks.
Thank you so much, Andres. When we were preparing this for this session, we had a conversation about the assets, the types of assets that are also publicly available in Norway. And Eiliv actually has if we can connect his computer, wanted to show us what type of information is available through various public databases in Norway. And one kind of difference that we found was about royal family rights. If you can tell us
Right.
whether Norwegians have information,
Yeah.
what type of information they can access on their royal family.
I'm gonna, just to be nice with my editor, I'm gonna ask you like not to take a photo and publish it, because that would be like distasteful. But if you swap, please, for the HMI. So Norway's kind of, you know, as a Norwegian journalist, I complain all the time, we should, you know, be allowed insight to this and insight to that. But whenever I work with colleagues from abroad and also doing the Dubai Uncovered, I realized how much information is possible in Norway, which is like, you know, like a lot. And we have, I mean, we have access to, for example, we have tax records. Yeah, no, yeah. We have tax records from all Norwegians are handed out to the media. We have to store them properly, use them for editorial use, or, you know, things like that. But you can also, as a private citizen, you can search the tax records for other individuals, other Norwegian individuals' taxes. So I just wanted to show you what that looks like, because it's sort of this Alice in Wonderland thing. We also have a very good system for property registry. You can look up everybody's property and find out how much it was bought for and sold for previously, who owns it, et cetera, et cetera. So this is what the tax records that I use is, and no photos just for the sake of my editor and myself, but so I can, if my editor, for example, who's the case study now, if he was owning, his name is Gard, he's a very nice guy. If he was owning a Dubai property, of course, I would be interested to see if he has any income that defends owning a $300,000 property. So I would, for example, type in his name, and I would do like this. Oh, here's my editor. So this is my editor's taxable income each year. And this is, so income is over here in the blue. Yeah, let's make sure you all get a good look. So this is my editor's income. It's $390,000 a year. And that's his wealth in the middle, and the amount of taxes, taxable wealth, taxable, the tax to the right? Taxable income, taxable wealth, taxable in his tax. Okay, so if I want to have a look at his career, I can see, oh, he used to be like me back in 2002, like he would, you know, be an ordinary journalist. And we could also have a look at the Prime Minister, and obviously, but he's not from Bergen, and he's not born in 1976. Obviously, we do not, and this is the point, with nobility comes, you know, responsibility. So we don't abuse this information. We use it for editorial use, right? And this is important. So we had a code of ethics that we work by. So here's the Prime Minister. Now, the Prime Minister makes, well, he makes less than half of my editor. That's a good thing. I think newspaper editors should make more money than prime ministers. But he does have quite a lot of wealth, because he inherited wealth. He's from an industrial family. And he does pay quite a lot of taxes. So you could look up, you know, bureaucrats, business people, whoever you want to look up for a story. Now, another thing we have, which I like, is we managed to crack open the stock owner registry 2014. The press got support from a judge that all stock ownership in Norway should be public. So we could, in the name of being, you know, a nice guy, I should, of course, also, when I sacrifice my editor, I need to look up myself, because he's going to be like, did you make fun of me in Washington, D.C.? I'm going to be like, no, I made fun of us. So this is me. And, you know, this rise of income is my overtime working with Dubai Uncovered.
Great.
Okay, so we do also have stocks. And we could look at, for example, you know, what people own for stocks. I'll use my editor again. So this is my editor. He has position in 2 companies. One of them is the ownership company of VG My Paper, and the other one is also, it's like a part of this group. So I can see Schibsted is a large media corporation that owns my outlet. So here are all the owners of Schibsted, industrial owners, but we could also look for smaller owners, and we can also, in a different system, we could look for example, Equinor, which is like a major petroleum company in Norway. And what was interesting some years back is that we found that bureaucrats were owning a lot of stocks in the businesses that they were actually physically controlling and expecting. Now they don't do that anymore. So this is Norway. Welcome to Norway, Wonderland. This doesn't pose any dangers to anyone. You know, that is kind of, you know, and it's publicly available information. That is the main argument. This just cleans stuff up. It's not dangerous. It's just cleaning. It's tidying things. It makes people not being corrupt because it's visible. It's not so bad.
Just missing a beneficial ownership information register now.
Thanks so much, Alif. Actually, Anita, we were discussing that, you were discussing that also in your papers and in your op-eds that the majority of countries actually don't have this type of transparency, right? And there are many loopholes when it comes to ownership of assets and wealth. Can you talk about a little bit about those loopholes and also some of the building blocks that exist in the current global financial architecture to change the status quo?
So let me first say, like 10 years ago, I would never have believed in a million years that we would start exchanging financial information across country, like the CRS, like automatically exchanging information from between 100 countries. So I wouldn't have believed that would ever happen. Now we have that. We have a system in place for that, automatic. And in the same way, I'm kind of thinking, okay, now like a global asset registry, it also sounds like utopia. But if there is a willingness, there's also a way to make it happen. And we need more exchange and more transparency. And we have these building blocks with the CRS and the FATCA, or like with exchange of financial information, and we have the beneficial ownership registries. And also, like you were talking about earlier, like all the loopholes in the beneficial owner registries with like 25% threshold. We don't we have a mixture of private and public ownership. We don't have like trusts, and like often it's more like a legal ownership register, not necessarily a beneficial ownership register, because you only have the legal owner, especially for trusts. And also there's like not necessarily a consequence if like failing or misreporting, but that's kind of, I think that's more like a starting hiccups. And if there's willingness to go for this, I think like the US and the EU, if they went together now, there would be, and like made this, like put all the building blocks together, there's a hope for having more caboose in the implementation, and also in like having more power in trying to fix these loopholes, because there's willingness that needs to be done, a political willingness.
Thank you so much. Next, I would like to ask Andreas this question. This cannot be the first time somebody has called global asset register utopia, right? This is it does sound like a utopian idea, but there have been quite a few conversations, and this is not the first time we're discussing the global asset register with multiple stakeholders and in this kind of setting. But it is the first time we're discussing this at the ICC, I think. Can you tell us where we are with the discussions and how advanced they are?
Yeah, so it's still in a way an idea, and I guess many of us are still discussing what the scope should be. Should it cover every type of asset? Should it cover only real estate? Should it cover assets based on the value? Only based on the holder of the asset? Should it be based on politicians or high net worth individuals? I mean, there's still discussions of what the ideal situation is. But as my colleagues were also saying, there's still a lot of things that have to be fixed. Two things I forgot to mention was that when I did the study of asset registries, like in the UK, the problem is that, of course, what we want ultimately is beneficial ownership information, like a natural person. And at best, we can have legal ownership information. But in many cases, it's not even legal owner either. It can be the holder, it can be the operator. So it's so bad what we have, and that's even in a case like the UK, where at least there is a registry. that there's still so many things to be fixing. I think ultimately, countries care about this. I mean, even in Argentina, there's a wealth tax, and basically not many people pay that. And so it's even in the interest of authorities, not just like NGOs and like people trying to tackle inequality. It's even authorities that are trying to enforce laws for money laundering and asset recovery, and also, but again, even applying inheritance tax or a wealth tax. So the basic thing that needs to happen is that these asset registries need to become better. I mean, they need to start at least collecting legal ownership data. And the BO registries, they need to start getting even more data on more companies. One of the things that will be discussed now, and I think Mayra might refer to that, of discussions in the EU, is to expand the scope. Many times, most countries, and this was something that also the FATF has changed, they only covered local companies. But now if a foreign company from Panama or BVI was owning assets in the country, there was no information about that. I mean, like nothing that the authorities had. So I think the key points and what most likely will happen, I mean, a GAR sounds a bit too big, so sometimes we speak of the NAR, like a national asset registry, like starting local. But there's still a lot of things that have to be done even before data can be interconnected, just because we don't have the data yet that we need. So of course we need to interconnect registries, and that will be almost like the first thing. But we also need, again, to cover the right types of legal vehicles. And even for those, or until we can get countries to move that, there's still other things that can be done. As I was showing, the forms that HMRC, the tax administration in the UK, uses for inheritance tax, already, it's like almost like a 20-page form for any type of asset. Jewelry, art, gold, anything. So we already have these forms. I mean, as long as we adapt them and we say, maybe every citizen has to report this on any asset they have abroad, we already have this legal infrastructure. It's not like a new form, like HMRC is already used to collecting these. So until we have these asset registries, at least we can start by asking citizens to report and to declare that. Of course, they will lie at the beginning, but at least we put, like, it's a legal requirement, and many of them might start complying. So I feel like there's some basic immediate steps that can be done while we keep getting this momentum and showing that, again, BO is just a tip, but asset information is ultimately what we need.
Thank you so much. Yeah, and as you teased, I think we have to go to Mayra next, and then we will open up to the audience. We said that we would come back to you for some insights on the way forward after the Court of Justice ruling. And let me also connect this with the question on the GAR. Well, EU, for the EU, as recently as last week, right? There have been conversations at the EU level, some very exciting conversations around the interconnection of the data, of various types of data, across the member states. Can you tell us how, if at all, the new Court of Justice, the new ruling from the Court of Justice changes that? And another question, if you could also expand a little bit on what are some immediate kind of wins that we can get in the 6th anti-money laundering directive that is currently being debated, that would bring us closer to the EU asset register.
Yeah, sure. Yeah, so I think there are maybe two issues that we need to take into consideration, right? Building on what Andres was just saying. I think number one problem in the EU and in other places is that not all types of assets are registered. So I think that's the number one problem, the first thing that we need to fix. So for example, at the EU level, arts, you can own arts, you don't need to register. You can have investments in crypto, you don't need to register. So that's problematic. The number two is that assets that are registered on the name of the legal owner, as Andres was just saying, so you don't necessarily have the beneficial ownership information. Even if you have a beneficial ownership register in that specific country, you not necessarily can combine these two data sets easily. And when I say you, I mean even authorities. So it's not that it's not available to the public, it's not available to authorities either. And then I think that the third issue, which Andres also touched on, is the foreign ownership, which is related to that as well. And I give one concrete example, that is France. France has an open beneficial ownership register. It's public. It's still public. You can still go there and search even after the ruling. It has in open data real estate register of legal entities that own property in France. You can easily combine these two data sets, which we have been doing with the Anti-Corruption Data Collective to analyze the information that is there, but you still have a loophole, that is foreign ownership. Because if I open a company in the BVI and I want to buy a property in Paris, I don't need to register with the BO register in Paris, so I can still do that in an anonymous manner, and nobody's going to find, although France has a very advanced system when it comes to registration and to accessibility of this information. So I think those are the three things that we need to fix at the EU level, and that we need to have in place in other countries as well. And the 6th EU Anti-Money Laundering Directive, and my colleague from TIU is here in the audience and can certainly add to that, but the 6th EU Anti-Money Laundering Directive was going in the direction of fixing those things, and we have been working to propose that the assets that are not, that the people register all types of assets, that beneficial ownership information is available for all types of assets. What the ruling does is that we'll shift a little bit, I think, of all of our efforts in civil society to try to fight for the basics again. And the basics is having access to the beneficial owner of companies that are used to own assets. And we'll shift also the energy of members of the European Parliament, of the Commission, and so on and so forth. So we definitely, when we start planning this session here, we thought that we are ready to move to the next step. And now I think we took a couple of steps back. But just to say on what can be done related to the ruling in the short and long term, I think in the short term, we have, as I said, this 6th EU Anti-Money Laundering Directive that is currently being debated in the Parliament. Just yesterday, the Council of the European Union agreed on a position. And it's quite worrying because it does recognize the role of civil society and journalists, as the court did. It does recognize that they have a legitimate interest, but it doesn't define how access should be guaranteed. And it's likely that it's going to be left for member states to once again determine how this will be done. And we had experience with that. We should not forget that before the 5th EU Anti-Money Laundering Directive was in place, that was exactly the provision, legitimate interest. And what happened? Journalists had to provide 2 or 3 pages of reasoning for accessing the data. They would be asked for IDs. They would be receiving redacted information. It didn't work. It's not going to work again. And we cannot repeat a mistake that we know is a mistake. And just one more thing, that looking at the text very quickly this morning, there is another thing that is very concerning in there. That is, member states will be able to decide if they want. They can share the information with the beneficial owner of who is requesting information and why. And this is not gonna, we're gonna be definitely back to where we were 10 years ago, where people could enjoy the good reputation of European companies to buy assets in Dubai and elsewhere, open accounts in other countries, and so on. So I think long term, very quickly, I know I already talked too much, but I think long term, I think a debate that we need to have, and I hope we can have this debate in the last 2 days of this conference, is how can we bring public access back? And we heard here a lot of examples that shows that having access to public beneficial ownership register is useful not only for fighting money laundering, but for a lot of other things, and to increase really trust in business transactions. We heard the example from Norway. So I think that's a debate we need to have. We need to find another legal framework, business transparency, I don't know, to bring back public access and to ensure that we know who are the owners of companies, to ensure that we can trust the companies that are operating in our country and that are investing also in other countries across the globe.
Thank you so much, Mayra. Does anybody on the panel have anything to add on the immediate? I think we can open up to the audience now, and I think we're also happy to hear your comments, not just the questions, on anything you've heard. Roland, I can already see. Yeah? Oh, please, Louise. Sure.
Thanks all for a really interesting panel. My name's Louise. I work with Open Ownership on beneficial ownership implementation. I had to say, Annette, my takeaway is going to be that there is more hope for more caboose on implementation. That will be my takeaway from the conference. But my question is, like, you've just all made this compelling case for public access, and thinking both about tax justice and anti-corruption. To my mind, that means we're talking about the very richest in society. Is this, in sort of thinking about an asset registry, is this about sort of certain types of asset classes that are most commonly owned by that demographic? Or is it more about having some sort of threshold just so you really target the highest value assets? So interested in views on that, thanks.
Should I answer or wait? Oh, go ahead. So I feel like, again, it's not like I can really respond of what the whole movement will do. This is just my personal opinion, and I think many of these things that we discussed, I think like 3 years ago in Paris, were like, again, which assets should be done. I feel like based on the experience of BO registries and BO definitions, I really dislike thresholds. So the idea of saying like only a house or any asset owned. I mean, some countries like even Uruguay are a bit more advanced, and they say register your beneficial owners if you are a local company or if you have more than $240,000 in assets. Like, how would you know that? I mean, there can be anywhere in the country. So I would say thresholds, I don't like them. So if I had to choose between every asset, or at least the main relevant assets, or based on values, definitely not values. I mean, like, they can just falsify documents, do that all the time. So yeah, definitely not that one.
Thank you. Next question.
Thank you very much. I'm Roland Papp from Transparency International EU. It's partly a question, so it's not only a comment. I think, can you hear me well?
So maybe some more distance?
Yes,
More
sorry.
distance to the mouth.
Maybe now? Now?
Yeah, better.
Okay, maybe also I stand up and it will be better. So I think we have a different, let's say, fights we need to pick. Maybe a bit of background, those who are not from the EU or something, or can't understand the EU institutions, that's totally normal. So what we have now is that we had the AML Directive Commission proposal last year. Now the Council has its position. The Parliament is still working on their position. And then at the end, they have to come together and like have a compromise of the compromises, and the Council being the ministers of the member states. And there, I think we have a different thing. So when it comes to the BO register, access, both the Council and the Parliament is pretty clear that they want to follow what the ruling said. First of all, they want to follow the ruling. And also they have the understanding that NGOs and journalists should have access, and they do have legitimate interest. So I think that's not that lost. The other question, I think, which is different from this, is what do we do with asset registers and any kind of different asset registers? For example, also the real estate register. The Commission original proposal said that, well, if countries have some electronic data system, that's great, and they should have some blah, 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 collect real estate ownership data. Then the Parliament, as usual, the Parliament is always more ambitious. The Council wants to water down things. And yes, it's the same with the real estate register. And so basically, the Council adopted, let's say, mandate says that they don't even need to have like an electronic database for real estate ownership. And now my point would be that one fight is for the BO register, the existing BO register, and how to do some, access and how to define legitimate interest, blah, blah, blah. The other side is to collect ownership data for some assets. And there, I think, maybe we should, after this decision, lower down our expectations and say of like, please at least have real estate data, have like, let's fight together with the Parliament against the Council, saying that like, yes, we need to get information about real estate ownership. Yes, the Parliament has ideas which regarding the value, like €1 million value assets, information to be collected and so on and so forth. My point currently, and please share your thoughts, even though I don't like it, but my point would be still that like at least trying to make sure to convince them that we should collect data for the authorities, and then let's see, maybe in 10 years from now we will get open access to that. Thank you. And it's a question whether you agree or disagree with me.
No, maybe just two things. The real estate, yeah, I think it's, I think I agree. I think real estate is crucial there. If we have to prioritize the class of assets, I would say company and real estate data definitely should be prioritized. But I think there are two other things. There is a provision on foreign companies that I think it's also something very, very important. So the proposal at the European level is that anyone investing on real estate through a foreign company or coming into contact with an obliged entity, so either opening a bank account or buying arts and so on, would have to register their beneficial owners. And I think this is good, and this is something I think we should continue fighting for. And on the legitimate interest, I don't think it's enough to have the legitimate interest in the 6th Anti-Money Laundering Directive and leave it to member states to determine how this will be implemented. And I think this is something we need to fight really hard. We have been discussing potential solutions, and I think one way forward that would be potentially a compromise would be that journalists and civil society are able to register once, enter in an agreement with the registry authority, and then be able to freely search on the register instead of having to, on a case-by-case basis, prove their legitimate interest. I think that's only, in my view at least, the only kind of agreeable compromise going forward, but I don't think it's going to be an easy win, unfortunately.
Thank you, Maria. Anita wanted to add.
Yeah, I would just like to comment on the need for a real estate register. So just to follow up of Norway, since we are both Norwegians, like as I have shown, it seemed like everything is perfect in Norway. We have like openness and registers and stuff. But even there, I have a new project now with my colleague Andreas Økland showing that like 10% of all real estate owned by corporations in Norway are held from abroad, and we see an increasing share owned from tax havens, and in particular Luxembourg. So that's been increasing over time. We see that, like we see, and then it's basically hidden. The authorities can't see who basically owned the properties that they rent for. And we have done this in collaboration with other journalists in a different newspaper who have been digging this and actually using the Luxembourg register before it closed down. And they went on case-by-case basis and searched down like the ultimate owners and showed often it was just the legal owners register, but then it ended up with some trusts and stuff. But this has proven like really powerful, like showing these cases, basically showing also like taking it home, like the ambulance planes in Norway is going to be sold to like the ones who have the contract sold to unknown owners. And then suddenly the politicians jump in that chair and like we can't have this. And then using these examples and saying, okay, you need to do this and this and this. And suddenly there's change going on, and I have discussions on the radio or the television with politicians saying, we will follow up on this. So I think the role of NGOs and journalists in showcasing cases and like making the politicians accountable is super important going forward. And we need real estate registers.
Thank you so much, Annette. We have still 10 more minutes. Oh, and we do have a question from Ms. Anna Gomes.
Ask you to speak about if there is an investigation going on about the company and the guy who actually got the court decision.
Okay.
He has links, it's well known, with an aviation group, links with Russia, with Russian partners. So is that part being taken care of?
Can you repeat the question?
Yeah. So the question was if the individual who sued the Luxembourg registers, business registers, if there is an investigation or if there is information on their connections to Russia. I don't know who is comfortable commenting on this.
I mean, I'm happy to. I don't think I can add much to that, but maybe just for those who are not aware where the case come from. So there were three cases actually that reached the European Court of Justice. This decision is in relation to two of those cases. And those cases were brought by businessmen from Luxembourg. They were first brought to the Luxembourg court And they had asked the register to exclude themselves from the register based on security concerns. They were afraid of being kidnapped. They said they travel a lot, and so on and so forth. And the court, instead of deciding on the exact question that was being posed, used this mechanism that exists that calls preliminary ruling and referred the case to the European Court of Justice with a much broader question than the one that was originally asked, that was, does it infringe in privacy rights and fundamental rights? Now, after the ruling, of course, everybody went to try to search and find out who these individuals are. And there is an article published by ICIJ. You can look for it a couple of, like last week, right? And in this article, they talk about one of the individuals who brought the lawsuit, who seems to have very close connections with Russia, business partner of a former KBG agent, and so on. Of course, I don't know whether there are investigations. I don't know whether there is something to investigate. I hope authorities will look into it if there is. Maybe he ended up attracting more attention to him now than if he had quietly put his name in the register, so quite unfortunate. But yeah, it really makes us ask questions about the real motives behind, right? I'm from Brazil, one of the most violent countries in the world, and everybody knows that it's not your name in a register that will make you a target of kidnapping. It's the car you drive, where you live, the clothes you wear, and so on and so forth. And so I do think that is a serious debate to have, no, on privacy, and nobody wants to expose anyone to risk, but you should also be in a position to show what risks putting your name in a register brings to you, and have a serious conversations about that.
Yeah, I would like to add one thing. I mean, when the Rota Armée fraction was kidnapping industrialists and their family, around Germany in the 70s, it wasn't because they had a public beneficial ownership registry. So this is, whatever argument they put forward, the problem is, I mean, from my perspective, sort of digging into, what is the motivation behind this lawsuit is kind of useless, because it's a waste of time and it doesn't really matter. What matters is that the laws arguing openness in Europe are too weak. And the other thing is that I do actually, in a way, and I don't mean to offend anyone, but I do sympathize with the argument that this register supposedly fighting terrorism is now turning into something else. And the reason it is, because like as a journalist, I don't fight terrorism. I write about financial crimes. So I use this register for something else. But the reason I have to do that is because me and my colleagues and transparency activists have not won the debate for openness. The argument for openness and transparency have not won forward in general. So we're sort of piggybacking on a registry created to fight terrorism. And when the registry is obviously going to be used for something else, it's going to be used for doing journalism, which I'm a big fan of, but then somebody's reacting to that and saying, they're taking to the court and they win. So the problem is we didn't win the argument for openness. That's what we're going to have to do. That's what journalists are going to have to do. That's what activists are going to have to do. We're going to have to win that debate, not let others, not piggyback on others' efforts. So that's going to be our challenge, not to try and find out whether this guy had a Russian contact or not. That's irrelevant.
Thank you so much, Eilif. Unless it seems like we have one more question. Yes, please.
Just one quick question.
It's not.
Here.
It's working now, right?
No. Here, take this one.
Thanks. I would like you to ask to elaborate a little bit on the decision, like what register exactly it concerns. Is it a business register of companies? Is it a real estate register? And you were talking a lot about registers over Europe being closed, public access being denied. Also, what kind of registers exactly it concerns? Are they business registers or other asset registers? And if asset, what kind? Thank you.
So the court ruling is actually about beneficial ownership registries of local legal persons. So again, it might depend because some countries have one register that covers both shareholder or legal ownership and beneficial ownership, and for any type of legal vehicle. The UK has actually one for legal and beneficial ownership for legal persons, and then another one for trusts. Luxembourg actually had one commercial register and then another beneficial ownership register. What the ruling is about is preventing public access to beneficial ownership information, not to shareholder, to beneficial ownership information of local legal persons, which are the ones covered by Article 30 of the directive. So on trust, I mean, some countries like Denmark actually give public access in open data to trust information, and I think like Denmark is actually keeping it open, and hopefully many others will. But the ruling for now is narrowed to those local legal persons BO data.
We have them just for one more question, one more final question, and then we have to close.
No. Maybe try again.
Maybe I can.
No. Oh, so, okay. Sorry, I will be short. It's more a comment than a question, but I would like to hear your opinion. So I'm Anna Turic from OCCRP research team, and we are working a lot with Cyprus. I mean, we were working with Cyprus beneficial ownership reports, and I wanted to point out something which now is, I mean, we have basic problems now with accessing a register, but something that should also be considered at some later stage is definitely the weak law that you mentioned about cases when, for example, in Cyprus, dissolved companies, there is no beneficial ownership data for dissolved companies, and there is no data for previous owners, and also there is, for some companies, just there is no data. And when we ask them, so what, why, and how, they are just like, data for this company, for these companies is not disclosed. So, so I just wanted to point out that it's not just a problem about having access to BO registers, which is obviously the first thing, but also how good that functions and what are our obstacles when we really look for those information. So I would like to hear your opinion. Do you think that at some stage it will be possible to overcome these kind of obstacles with maybe good laws or anything, or with our fight? Thanks.
Yeah, just very briefly. So that map that I showed, that was just green, blue, and we have a very complicated version of that map. That was the version we were working with before this. And that version actually talked about the things that need to be improved related to access, to search functions, to quality of the data, and so on and so forth. So the registers, when they were public, they were far from being perfect, and they certainly need to be improved. And in the case of Cyprus in particular, well, the government has been taking forever to actually implement the directive, right? And has a system now not working anymore, but was also far from perfect. Like what the government did, they said, our register is now open to the public. Please come in person to the registry authority. Now email, but officially, it says, come in person to the registry authority or send your request per post. So that was the system. Now we managed to access this data per email, so you send, you make a payment, they send you back per email what you want to see. You can never go in and search as you see fit. That's not an option. The other reason, very briefly, on why for some companies you don't find the information is because they keep postponing the deadline for companies to submit the information to the register. It used to be March. When the war started, it was postponed to end of July, and now it has been postponed to the end of the year. So you're free not to submit your data, and you cannot be punished for not doing so until the deadline is over. So.
Thank you, Mayra. And now we're officially over time, but before we go, actually, we thought it would be a good idea for every speaker on this panel to share a very brief takeaway, one message. We're at an international conference where we have governments, civil society, media, and businesses. So it would be great, so if each speaker could kind of issue a call to action in under a minute, if at all possible, and we can start from Eilif and then end with Mayra.
Right, thank you. Well, as you know, I'm a journalist. I'm not a transparency activist, but the only thing I can have a political opinion about would be openness and transparency. So I'll be very narrow with just saying that in the long term, I think as journalists, we're going to have to win the fight for transparency on our own premises with our own arguments, not piggyback on others, unfortunately. And I think the way what happened with the beneficial ownership registry proves that point. And I think we're gonna, in the long term, and you guys as well, are gonna have to try and argue how openness is protecting those without large voices and a lot of money, because that's what FOIA and transparency does when it's used the best way possible. So thank you for having us, and hope you have a great conference.
Transparency is important and transparency is good. We also need to remember that we need to have a separate trail of action, like to be able to have law changes and sanctions and willingness to be able to seize the fund, to recover funds, illicit gains that are hidden in safe havens. And what we saw in the Dubai papers and the data, very tragically, like overrepresentation of like autocratic and war-ridden countries, and those countries will need those gains to be recuperated. So that's another path that needs to be taken to get funds back to the countries. Thank you so much.
I mean, I guess for us it's really a matter of changing power dynamics and changing really most things like systematically. In a way, again, there are rules that apply for everyone else. I mean, that's what the law is supposed to be, like for everyone. And we've seen this mostly in the tax world where I come from, in that constantly tax rules are being exploited just to benefit a few companies that should be paying a lot of tax so that they will not pay any tax. And now the ruling is almost a case like that. They're using human rights arguments that, again, are supposed to really protect human rights. And it's just to protect, most likely, I mean, even though we don't know who this person is, it will eventually be used by the criminals or those who want to be staying above the law. So the fact that all these people can be using these good arguments and these good rights that are meant to be protecting everyone, and especially those most vulnerable, but are actually used to protect the wealthy and the powerful ones, that's where we need to start addressing and changing so that they are really subject to the same laws that apply to everyone else. And I think that's why what was discussed, I mean, many of the ideas I'm sharing now, it's because of Chatham's rules and like what other people have been saying in many of the workshops I went to. Information is really about this power struggle and this change and shift of power. The wealthy and the criminals, they have the data. It's the rest of us who don't have the data about them. And that's why we need this data. It's really to be shifting these dynamics and these injustices.
Yeah, I agree. No, I think it's definitely, we definitely believe in the power of information to bring more accountability also and justice, right? And fairness, that's what we are fighting for. We don't fight against corruption just for the sake of it, because we want fairness, we want a just society. And I think only with radical transparency and with proactive information is how we're going to get there. So we'll continue fighting.
Thank you so much. Thank you so much, everyone, and have a great conference. We'll continue these conversations also throughout.